Hello and welcome to Ipsy Dixit, a podcast on legal scholarship. I'm Mabel Romero, Assistant Professor of Law at Northern Illinois University College of Law. And today my guest is Jennifer L. Brinkley, who's an Assistant Professor of Legal Studies in the Department of Administration and Law at the University of West Florida, and she's a licensed attorney in Kentucky. Today we're going to be discussing her paper, The Failure of Amanda's Law in Kentucky, Creating Best Practices for Legislatures Passing Domestic Violence Statutes, and this was published last year in the Quinnipiac Law Journal. So thank you for joining us this morning, and I'm looking forward to chatting with you about this.
Thank you so much for inviting me. I'm very excited.
So can you tell us, this paper starts off with a really kind of shocking and scary story. The story about Amanda Ross, who Amanda's Law is named after. Could you just inform our listeners just what happened with her and how what happened to her really, gave inspiration to the drafting of Amanda's Law?
Sure. So this paper really talks about two primary individuals, one being Amanda Ross, and the other was Steve Nunn. And Steve Nunn has a very political history. He was the son of a former Kentucky governor, Louis Nunn. He served as a state representative for a very long time in the Kentucky House of Representatives. And at the time of this happening, he was serving in Frankfort, which is the state capital of Kentucky, as Deputy Secretary of the Department of Health and Family Services. And this is an organization that basically is over things like child abuse and neglect cases, domestic violence, things of that nature, anything basically dealing with family services. It's now called the Cabinet for Health and Family Services. But he and Amanda Ross was someone who was working in Frankfort and had political aspirations of her own. They began dating in 2007, and everything seemed great for a while. They even became engaged in 2008. But then the relationship became violent. And on February 17th, 2009, they had a physical altercation. And so in Kentucky, you can file an emergency protective order to obtain emergency protection from an individual that has committed an act of domestic violence. And that's what she did. She filed an emergency protective order. They had a hearing, and the judge entered a domestic violence order against Steve Nunn. And so this order had provisions like they could not have contact with each other. He could not possess a handgun. And so he had fallout from that. He had to resign his position with the Department for Health and Family Services because this domestic violence order was entered. He also had been charged criminally with misdemeanor assault. He ended up pleading, entering an Alford plea to that in August of 2009. And then in September of 2009, on September 11th, Ms. Ross was walking to her car in the very early morning on her way to work when neighbors reported that they heard a scream and multiple gunshots. And she was shot to death outside of her home in Lexington. And they found Steve Nunn about 100 miles away. This is where the story gets a little odd. He was at the grave sites of his parents. He had slit his wrist, but only superficially. And when law enforcement approached, because during their investigation, they discovered the domestic violence order, and so they started a statewide search for him. And they found him at the cemetery. When they approached, he fired a gunshot and at himself, but he missed. And so he was arrested and charged with wanton endangerment. He was taken to the hospital, but like I said, the wrist wounds were superficial. And so he was ultimately charged with murder and violation of domestic violence order. And about 2 years later, he entered a guilty plea, and the wanton endangerment charges were ultimately dropped upon the entry of that guilty plea. And then the legislature in 2009 began very rapidly trying to create domestic violence statutes. I think in a response, because this basically had been one of their own that had committed this again. At the time it was a alleged act, and they wanted to look like they were taking it very seriously, and so they started drafting legislation titled Amanda's Bill, which became Amanda's Law.
So Amanda's Law, it looks like it amended at least then existing domestic violence statutes in a few big ways, but what your paper mentions is that the biggest change was the ability of courts to order domestic violence offenders to wear global positioning monitoring systems, right?
Yes, that's right. So it made lots of changes. Uh, Probably one of the best changes, I would say, is that courts could now obtain basically a protective order history of people that were before. So Kentucky is a family court system. Now, not every county has family court, but those that do, that's where domestic violence cases land. And so the idea of family court in Kentucky is one family, one judge. And so, whatever your family law issue is, that judge remains consistent. And so, in those cases, the court could now request and review the respondent's criminal history and protective order history, which hadn't been done before with that protective order history. And so, within the very first year of the enactment of Amanda's Law, the AOC, which is the Administrative Office of the Courts in Kentucky, processed 25,843 background checks. So that was a great reform that came out of it. The GPMs, the Global Position Monitoring System, was certainly had good intentions. Its hope was that if someone violated their domestic violence order, then the court could order them to wear this device, which is like a home incarceration monitoring device. And so the survivor, the petitioner, would get notifications if that person was within the no contact space. And so it was really great intentions. The problem was was several. One, the state provided no funding for these devices, and so counties were faced with this unfunded mandate of trying to figure out how to pay for these devices. There's a daily fee for the devices, just like with home incarceration. And so, if you have an indigent respondent in that domestic violence action, then the county is footing the bill for them as well. The county was footing the bill for paying for getting these devices in the first place. And so you had a lot of very unhappy counties in Kentucky, and there's 120 counties in Kentucky, unhappy with the fact that the legislature provided them no money to fulfill this mandate from them. Another issue is that it wasn't like, if I'm a domestic violence victim or survivor and I file a petition, that I could ask that judge, hey, I want them to wear this device right now. It wasn't available until the court entered a domestic violence order. The respondent somehow violated that domestic violence order, then was charged criminally with a misdemeanor for a violation of that domestic violence order, then went through the criminal process and either entered a plea of guilt or was adjudicated guilty in that case. And only then could the petitioner bring that back to the family court or the district court, if they didn't have family court, and ask for this global position monitoring system. And so the hoops that survivors had to go through made it nearly impossible, or improbable, I should say, for them to actually use this law in the way that it was intended.
So I'd like to talk about the history of domestic violence, not just in Kentucky, but also nationwide. And it looks like right now Kentucky defines domestic violence and abuse as physical injury, serious physical injury, stalking, sexual abuse, strangulation, assault, or the infliction of fear of imminent physical injury, serious physical injury, sexual abuse, strangulation, or assault between family members or members of an unmarried couple. Now, the understanding of impermissible sorts of violence in the home did not used to be quite so broad, right?
Right. And actually, in Kentucky, it was just a few years ago that um, the domestic violence statutes were amended, I believe in 2016, to even include things like stalking and strangulation. And strangulation is a huge risk factor for potential later fatality. And so it wasn't until just very recently that the legislature brought in this definition that the domestic violence orders and EPOs, emergency protective orders in Kentucky, used to not even apply to people who were dating. And so you either had to be married or you had to uh, have a child between the two of you. It wasn't applicable for those who were experiencing dating violence. So finally, the statute was amended very recently to include those members, as we know, that were faced with domestic violence as well, and should have been protected all along.
But domestic violence wasn't always a crime or even something that you could take action against otherwise in the United States, right? Your paper details that the first laws making domestic violence illegal were enacted by Puritans in 1641. Could you tell us a bit more about that?
Yeah, so that was a really interesting part of my research, and was kind of going into, and the paper just gives a very brief detail of this, but basically, where did this idea of domestic violence becoming either a criminal offense or something we can um, deal with in civil court, where did that begin? And so, yeah, in 1641, the Puritans basically were the first to make domestic violence illegal. And so the law there was applicable to married women, and basically said that, husbands, you are not to basically physically assault your wives unless she assaults you first. So there was kind of that self-defense provision built in, I guess, there in 1641.
Mm-hmm.
But yeah, and so as we go through, women, we have this whole romantic paternalistic history where women were seen as the weaker sex, and husbands were the heads of the household. Women were expected to remain in their basically domestic sphere while the husbands went out into the workplace. And so women did not have a lot of rights. And in terms of uh, things like being able to decide what to do with your own property. It wasn't until the mid 1800s that states began passing what we call Married Women's Property Acts. But in terms of domestic violence, I wanted to look at some cases about how courts were handling that. And I talk about one case in my paper, a Mississippi case, where Judge Ellis, who was serving in Mississippi, really became the first in the United States to create this precedent of lawful wife beating. So we had this case where the husband had been convicted of assault and battery on his wife. He appealed, saying, "Look, I should have been exempt from prosecution because the victim's my wife, and I have every right as the husband to correct her and use physical force to do so." And so the court didn't quite go that far, did not allow that wife exemption in terms of being prosecuted for assault and battery. But the judge was very hesitant. And he was talking about in this case, the case is Bradley versus State. It's an 1824 case out of Mississippi. Um, he basically talks a lot about how these family issues should be kept within the family. We should not be allowing these kinds of things, men correcting their women, to be brought into court because you are basically, um, you know, he says, casting a shade over the character of those who are unfortunately engaged in controversy. And so he goes on to say, to screen from public report those who may be thus unhappily situated, let the husband be permitted to exercise the right of moderate chastisement, and so moderate physical force. And basically goes on to say these things should not be prosecuted. In 1862, you get a similar type of decision in North Carolina, where a wife was trying to divorce her husband. Now, at this time, we didn't have no fault divorce in this country, so you had to show cruelty or adultery or something like that. And so she was saying, look, he's hit me with a horsewhip, he's hit me with a switch, he's left multiple marks on my body. And basically, the court said, sorry, every man must govern his household. And if by reason of an unruly temper or an unbridled tongue, the wife persistently treats her husband with disrespect, basically, if he allows that, then he allows himself to lose respect within the community. And so the law gives the husband power to use such a degree of force as is necessary to make the wife behave herself and know her place. So in that case, she was not permitted a divorce because basically she did not prove that the violence was bad enough and that it wasn't caused by something that she did. But what I found really interesting was that just a few years later, Alabama throws some shade at both Mississippi and North
Yeah.
Carolina because we have this case very similar to the one I talked about, where the husband was charged with assault and battery on the wife. He was convicted. Wanted to say the same thing. Hey, the court should have instructed the jury that this was my wife and I'm permitted to do so unless I'm excessively violent. And the trial court refused, stating that it was barbaric to allow this type of instruction, even if it was permitted in North Carolina or Mississippi.
Oh,
And
yeah.
I just loved
That's
that.
a major
I thought
shade that
that
they're throwing right there. Seriously.
right. Exactly, and from the Supreme Court of Alabama, not the most progressive of states historically, I suppose, and so I just really thought that was interesting that they were engaging in that kind of throwing of shade before that terminology was even even known. So certainly an interesting
Wow. So was
case there.
Alabama the first state to take this sort of position? Like, no, hold on.
Right, right. Yeah, it's an 1871 case, and basically they said, and I put a quote in my paper because I thought it was really interesting that yeah, they say they're talking about the wife, they're talking about how, she is entitled to the same protection of the law that the husband can invoke for himself. She is a citizen of the state and is entitled in person and in property to the fullest protection of its laws. Her sex does not degrade her below the rank of the highest in the Commonwealth. And this is 1871, so this is right after the Reconstruction Amendments are developed. And at this time, though, the Equal Protection Clause does not apply to cases dealing, where sex is being treated differently. And so, I just thought this was a really interesting view by the Supreme Court of Alabama, and certainly something important in the history of domestic violence, but also a little comical because of how they're, dissing other states in their in their opinion.
So I'd like to shift our attention back to Kentucky
Sure.
specifically. So let's talk about some of the efforts that have been made in Kentucky to try to combat domestic violence since the early 80s.
Yeah. So when I was researching this, and I found this study. It was done in the late 70s in 1979. And so there was a study of 1,793 married women living with a male partner in Kentucky. And I thought, oh, that's really interesting because that's during, this whole shift of when we're finally starting to recognize domestic violence. And so the study indicated that 10% of female partners experienced physical abuse at the hands of their spouse or their male partner in the past 12 months. And then it also looks at this infrequent nature of reporting. So we know that domestic violence, at least we know now in 2020, that domestic violence is underreported. And so we even see this in 1979 that the nature of the incidents being reported to police were called in, and only 9% of the incidents reported. So we see this underreporting already being documented in the 1970s. The first domestic violence shelter in Kentucky opened in Louisville in 1977. So within the next 3 years, so up to 1980, we see 6 shelters across the state open to serve women and children that are fleeing domestic violence. Today, or at least at the time of writing this, there were 15 shelters across the state. So one would argue that's probably still not enough, but it's certainly better than the one in 1977. And in 1984, Kentucky came along with other states and allowed civil protective orders to be issued by domestic violence survivors. And so that's when we finally see the response legislatively in 1984. And it goes through just a myriad of amendments through the years of the steps that survivors can take. And then all the way up to very recently, where we include dating violence, we include strangulation, we include stalking, which wasn't included before either. So it's this constant, I guess, it's a fluid statutory response as we learn more about domestic violence and as we see trends in domestic violence. But it always seems to be a little bit behind, unfortunately. But at least there is consistent effort to make changes to help serve survivors. And so in this paper, I'm not trying to dog Kentucky. I was born and raised in Kentucky. It's certainly very important to me. But I do think it's important to look at where we've come from in terms of these statutes from 1984. Certainly good intentions with Amanda's Law, but it's just not working. I did an open records request last summer to the AOC, the Kentucky Administrative Office of the Courts, and wanted to know basically what I wanted to know was how many times have these devices been ordered from January 1st of 2010 to when I did the open records request, which was July 17th of 2019. And through that 9-year process, there were only 3 cases documented with the AOC where a global position monitoring device had been entered. And so it's just not, it certainly had great intentions, but I think they need to go back and try to make the process to get this device a little less cumbersome, because we know that domestic violence survivors are traumatized when they go to court and have to deal with seeing the respondent again and having to deal with criminal charges and then going back to a family court or a district court, wherever, whichever county they're in. It's just so difficult for them. And the idea that they can miss work and they can just kind of drop everything to attend all of these hearings is just something that doesn't make sense in reality. So it would be great if the process could be a little bit friendlier for survivors in order to obtain this type of protective device.
So let's talk about how GPMS tools work and maybe some of the drawbacks to them otherwise.
Yeah, so I wanted to see, okay, how is this working in other states that have this type of program? And so I looked comparatively at what other jurisdictions were doing, and that could be an entire paper of its own as well.
Mm-hmm.
and so, and so some of the concerns that GPMS has in other jurisdictions were what I briefly mentioned before, is that there's technological issues with them. There's financial issues with them. Say you have an indigent respondent that cannot afford not only the initial cost of wearing the device, but the daily fee for wearing the device, then that falls on the taxpayers to pay for that. That falls on the county to make sure that they have the funds available for that. You've got the technological issues. In a state like Kentucky, there's all sorts of, I guess you could say, technological deserts in terms of good access to reliable and consistent technology. And so when we're looking at these kinds of devices that rely so heavily on internet access, on technology, then that's something that needs to be addressed within the state of, making sure that we have the right type of technology that's consistent and reliable across the Commonwealth of Kentucky. Other issues were false alarms. Sometimes, if the offender didn't charge the device, a false alarm will be sent, and so the victim or survivor would be notified, and that would be an issue. There was a study in Florida of GPMS devices that showed that actual violations accounted for 23% of the alarms, and so that leaves you with 77% being basically false alarms. So either the device didn't work, there was some sort of loss of a signal, and that's not great numbers to look at. There was also one, and I don't know if I put this in the paper or not. Oh, yes, I did. I'm looking right now. That monitoring companies are not always vigilant in sending alerts for violations. So there was a Florida case in 2017 where a husband had been wearing this device, and basically he went to her house in the middle of the night. The monitor alerted at 2:05 a.m. that he was within the area he was not supposed to be in. But for some reason, law enforcement didn't get a notification from the monitoring company until 7 hours later. And so they responded to the home once they received that notification, and they found that she had been murdered and he had committed suicide after doing so. And so, again, these devices aren't 100% foolproof. There's certainly another layer of protection you could think of, but again, you don't want survivors to be lulled into this false sense of security that, okay, I've now got this device and it's going to be everything's going to be perfect. I'm going to be 100% safe. That's just not the reality of the situation.
So, how do I put this? I've had the lovely opportunity to spend a lot of time in your home state of late. And,
It's a wonderful Commonwealth.
I've really been enjoying it. But something that has surprised me about it is learning that there are 120 counties, which is a shock to a Westerner like me. I'm from California, and there are 58 counties. I have lived in Utah for a while, and these counties are huge. So there are 120 counties. Does that create some difficulty in implementing Amanda's Law and a lot of these other domestic violence statutes with regard to decentralization?
Oh, absolutely. Yeah, I mean, Kentucky is unique in that the size of its landmass and how it's divided up in 120 counties is just a really unique thing. But certainly, I mean, if you go, so in each of those counties, um, sometimes there are uh, so you have county attorneys that handle misdemeanor offenses in those counties, right? And so now in some counties in Kentucky, you may have a couple counties grouped together where maybe the felony prosecutor, the Commonwealth attorney, is over a few different counties. But so you've got all of these individuals with different mindsets, right, about domestic violence and about how survivors should cooperate. We know that many times survivors recant. And so I was a prosecutor uh, in Kentucky, and I did misdemeanor offenses, so assault fourth offenses, which were these domestic violence assaults. And I can't tell you how many times I had uncooperative, of course, I used the terminology victims at that time, that just didn't want to participate. And it was for 1,000 different factors. Maybe he or she was the primary breadwinner. Maybe, I heard all the time about the feelings of love and how they didn't want to testify against this person. Child support issues, child custody issues. They didn't want their child to be alone with the other person. I mean, there was just countless factors. And so we all, in each county, you've got different ideas about how these kinds of cases should be prosecuted, but also even within prosecutors' offices, you've got different prosecutors with different ideas. So I worked with a male prosecutor who we just basically agreed to disagree because I was fundamentally against what he would do with an uncooperative victim. In his cases, if the victim no longer wanted to cooperate, he would sometimes would dismiss the assault and then file charges against the victim for
No.
basically, yes, filing a false police report. And so I just, I thought that was completely wrong because you have to understand the factors, you have to understand the cycles of domestic violence. And it is not uncommon for victims, survivors to recant. And so putting them in that position was something that I just disagreed with. So I say that because I think it shows you that even in one county, right, you can have very different ideas about how these cases should proceed. So multiply that by 120, and you've got just massive inconsistency with how these cases are treated, both criminally and in the civil context.
So, in closing, what I wanted to do was ask you, what are some paths forward that the Commonwealth could look at or should look at?
Yeah, so I think that again, they need to make the process less cumbersome. They certainly need to, and when I say they, I'm talking about the legislature, um, provide funding for counties. If they are if they are truly sincere about these kinds of devices, they need to provide each county with the funding to be successful. And so to be able to have these devices and be able to have enough funding to cover daily monitoring of these devices is certainly something that I think is an important step. But I also think making the process, looking at it from, okay, if I really want to impact survivors. What does it take for them to get this type of divorce? What kind of steps do they have to go through, and how can I make that easier for them? I think that that would be a really interesting perspective for them to start from. Um, Also, at the time of this, at least when I wrote this, Kentucky did not have a statewide domestic violence fatality review system. So compiling data on fatalities resulting from domestic violence is not the easiest thing in the world. And so now there are some jurisdictions that have these types of review teams, but it would be great to have a statewide fatality review system so we can make sure that our statutes are truly addressing what needs to be in there in terms of protecting survivors. So like a couple of years ago, they added stalking, they added strangulation, which are really important because, again, like I said, strangulation is a huge fatality risk factor. And so if we could have a statewide data collection, I think that would be something that could certainly inform our statutes. And again, I think improving the Commonwealth in terms of its access to technology, especially now with, pandemic times when we're all trying to access technology, either for school or work or whatever. It's certainly something that I think needs to be invested in. Especially if we're using things like cyber stalking are now included in our statutes, then we need to be able to be addressing things like technology use and internet access and things like that. So those are just a few of the things that I think should be, I hate to say, throw money at the situation because that's not always an answer. But in this case, I do think counties should be provided the financial resources they need in order to really be able to say, okay, court, yes, if somebody wants one of these devices, we have them up and ready to go. It's hard for a judge to say, yes, I'm going to order this GPMs device when they know that their county has no access to them. And so, 3 examples of these devices being ordered in 9 years is not a good track record in terms of this legislation being successful. And so I think that, those kinds of things, increasing access to technology, funding these mandates that they're putting upon counties, and really looking at good data collection, I think would be a great place to start.
Well, I think that this is a really important conversation to have and a really important paper. Thanks for taking the time to talk about it with me. Everyone listening, go ahead and download it from SSRN or find it at the Quinnipiac Law Review. And it sounds like there are a lot of things to follow up on in here, so I'm looking forward to talking to you some more when you write more, just future papers on this. This is exciting.
Thank you. Thank you. Thanks for having me on.
True love, let it fall behind me. True love, tie me up and blind me. I've been thinking about it all of this time, and I've been acting like we're catching on fire. Oh,